I would never recommend these policies. I think they're really ill-informed and bad policies. But at the very minimum, you need to have an adversarial hearing, and you can have an emergency hearing. You can go and bring the person before the court, provide them with a lawyer, and then the state would have to prove beyond a reasonable doubt that these factors are in place. But that's not the case right now. What they're pushing for so much is to have ex parte hearing. And if you look at we at Firearms Policy put through a lot of record requests to find out what's been going on in California. More than 10% of the cases, they don't even claim to have given any notice to the person who's subject to the order. How does that make any sense? You're claiming to be doing this for public safety. The person you're claiming that you're purporting to take the weapons from doesn't even know that this order's been granted. So where's the advantage aside from making them into a felon now for something that they could not possibly know anything about? And not only that, like you said, it does tie nicely into civil asset forfeiture because let's say, okay, order's granted, firearms are confiscated. Then, after the period, the order's dissolved. There's no permanent injunction put into place because there was no real solid grounds to issue the order in the first place, as is what happens with over about half of the orders that are granted in the states that have released data on this so far. In the vast majority of those cases, the people never get their property back. And why is that? Well, you need to go through process to get through that, and the government, if you've ever been to a DMV, they're not really excited to do anything for you, are they?
Yeah,
so
user-friendly, not really associated with the government all that much. It's interesting.
Right.
I think this is an interesting conversation in that, there are some smart people, I think, on the conservative side of things that are arguing, look, you could see the downsides. You could see that people would be falsely accused. You could see that the government would never get their stuff back. But, this is a big issue. We're talking about maybe 20, 30 people dying in a shooting. If you can get a certain level of protection where, the hearing has to happen within 72 hours and the stuff will be returned immediately. And, is there any sort of hurdle that can get us to a place? I mean, to me, it just seems completely unconstitutional. So I don't know how you do this in the first place. But is there any sort of restriction that can push the government back enough to make something like this viable?
I mean, we've been researching this a lot. We're putting out everything that we have on the website, but the way they are right now, it's so far from passable that I can't think of a way to save the existing law, and still be consistent with the Constitution. And when people talk about saving lives and stuff like that, this is not about saving lives, right? This is about just making an incremental step in gun control, because these things can't work without registration. Because say you get the order, something like that. How do you know what to seize from the person? If the person's truly dangerous, why are they not going to hide an extra weapon and give you, oh, that's all I have? The government is barred from having a registry, so this cannot be effective. But on the other hand, it's going to affect a lot of people. And you see in California, they're wanting to expand it now to include basically anyone who's ever had more than a 5-minute conversation with you will be able to bring one of these orders. This sets up a very perverse system of incentives. We're in a culture right now with swatting where people are able to use the government to murder their enemies. You want to add another tool to that toolbox? We already seen one person in Maryland die as a result of a no-notice gun confiscation rate.
Yeah, I mean, that swatting stuff is terrifying. And